Good evening, and thank you for coming. I'm Michael Ettinger from Ettinger Law Firm, and this is our estate and financial planning workshop. It's based on my experience. I've been a lawyer since 1980, so you can all do the arithmetic. But the last 23 years, it's been just elder law estate planning. And in that time, we have prepared many thousands of estate plans. We have settled perhaps 1,000 estates, filed a few thousand Medicaid cases, and so I believe we have a fairly good handle on the types of mistakes people make and how to avoid them. So tonight is intended to be sort of a litmus test for each of you to see where you stand, what issues you have addressed, what maybe needs a little bit of work so you can each get to where you want to go. And that's a particularly safe and secure place of knowing that no matter what happens, you have a very effective plan to deal with it. And by the time we're done in the next hour or so, I believe you'll have a very good idea of where you stand and what, if anything, you need to do. So let's get started. Okay, if you would, please open your Ettinger folder. On the right side, there's a review of my book entitled Ettinger on Elder Law Estate Planning, published on Amazon. Well, what is elder law estate planning? It breaks down into estate planning, which has been defined as getting your assets to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. And we all need an estate plan because the mortality rate is alarmingly high. Estate planning has been around for about 1,000 years. The King of England invented it around 1200 to be able to collect taxes from his subjects when they died. Elder law has been around since about 1988, when they formed the elder law section, the New York State Bar. The reason elder law is the new kid on the block is because it's only in the last 100 years or so that people started living a lot longer. Do you know that we live an average of 31 years longer than we did a century ago? And the bar started to recognize, especially in the last 50 years, that this was creating legal issues. For example, today about half of all people become disabled, usually later in life, unable to handle their affairs. Well, in that case, who's going to handle their legal and financial affairs? So we have powers of attorney. Who's going to make medical decisions for them? That's the healthcare proxy and the living will. Do you know that New York's healthcare proxy law was only passed in 1993? So we also have in elder law guardianship rules. We have Medicaid. How do you qualify? What assets can you transfer? What's protected? What's exempt? How do you set up a Medicaid trust? And in this book, I argue it's really one subject. Everyone needs an elder law estate plan because while everyone has to pass from this good earth, about half of us are going to become disabled, and we just don't know which half we're in. So that'll be the subject of most of my remarks tonight. What is the elder law estate plan? If you look at the next item in your packet, it says, why choose Ettinger Law Firm? Well, the reason we bring it up at this time is because we invented, I actually invented it myself, a unique process. It's trademarked in Washington in 1999. It's called the Ettinger Elder Law Estate Planning Process, and it's designed to make our plans work when you need them. Everyone else designs them to work when you write them. Here's what I'm getting at, because most of you have had this experience. At some point in your lives, you probably went to a lawyer's office and had a consultation with a lawyer, and you told him or her who you wanted to leave your estate to and what the percentages were, and who's your executor, and who's the second choice. And then probably a few weeks later, you went back to the lawyer's office and signed the will. You remember this. Most of you have been through it. Now, was anyone here hoping to use that will in the next few weeks after that? Maybe the next month or two, probably not. More likely, you're going to think about using it 30, 40, 50 years later. So what chance do you think 30 years later these executors are the same person you wanted 30 years ago? Or the beneficiaries are the same? Or the percentages are the same? Not a very good chance. And you'd be right, because so often when someone dies, we trot out the old will, and it causes a lot more problems than it solves. Why? It's a defective design. It was designed to work when you signed it, not when you need it quite a few decades later. So I formed Ettinger Law Firm in '91, and I had been doing the estate planning work for about 7 or 8 years before I started to realize this was a problem. And when I looked into it, I found out that there was no solution to it. So I invented one. It's rather simple. It's a 4-part process designed to make the plan work when you need it. Over 10,000 clients use it today. First, we have a newsletter we send out once a week to all of our clients just to keep them informed, and we call it the Ettinger Elder Alert. It's called the Alert because it comes by email. Now, the law doesn't change every week, so one week it might be legal, another week financial, another week medical, another week social. But it's our way of staying in touch and letting you know when there's a law change that affects you. Every 2 years, we invite all our clients to breakfast, and we update you on the law and what's happening in the firm. It's just to build a relationship, see our clients, see you're doing well, and maintain the relationship and the contact. We have a computerized tracking system that has all of our plans in it, so when there's a law change, the computer can search the whole database, tells us which clients it applies to, and sends you a letter. So you never really have to worry if you're legally up to date. If there's an issue, we'll send you a letter and tell you about it. But the key is this. Once every 3 years, we send each client a letter, and we say it's time to come in for your free review. The reason we ask you to come in is because we have no other way of knowing. Did your health change? Have your assets changed? What about your family? Births, deaths, marriage, divorces? So here's how it goes. Client comes in after 3 years, very few people need a change. After 6 years, naturally, more people need a change. But it turns out almost no one gets past 9 or 12 years without needing a major change. Who's in charge, who they're leaving it to, something else happened in the family. So you make the change, then we charge legal fees to do the work to change the documents, and then you're good to go. The point is, when you go to use the plan, it's never more than 3 years old. Designed to work when you need it, not when you wrote it. Now, I designed that process for defensive purposes, but I learned from using it, it has a very good offensive effect, and that's this. Each one of us turns out to be a much better planner if we only have to plan for the next 3 years. If you know you're going to see the law firm in 3 years, then if you have an issue in your family, maybe a son or daughter in a shaky marriage, or maybe a financial problem or mental health issue, you may want to hold it back for now. Put somebody else in charge. Spill it out over a period of years. Put it in a trust. Knowing that you're looking in 3 years, maybe you won't need that protection. In 6 years, you might not need that protection. It's just a very good way to plan. And most of us can see, 3 years ahead, but none of us can see 30 years ahead. So I recommend it to you. It works very well for our clients. Now let's get down to the meat and potatoes of the workshop this evening. And the theme is the major reasons why wills are obsolete. And I'd like to focus on the 4 major reasons. And I'm talking generally for clients 60 and over. And this is not news. Do you know that wills have been obsolete for about 2 decades? And here's the first reason. The will takes effect when? When you die, right? And as I said earlier, that worked pretty well for about 1,000 years. But it doesn't work so well anymore because today, about half of all people eventually becomes disabled. Now, if you're unable to handle your affairs, does the will help you? No. So the will is not a plan for disability. What do you think happens to thousands of New Yorkers every year who become disabled and can't handle their affairs, and they don't have a plan? Many of them end up in guardianship proceedings. What happens is a friend, a relative, a neighbor, a professional, doctor, dentist, lawyer, or someone else calls up Department of Social Services and says, you're acting a little bit strange. Well, they have to start an investigation, and just as often as not, they'll appoint a legal guardian to make sure that you're okay and to protect you. And this is done by a judge of the Supreme Court of the county in which you reside. So for us, a judge here in Poughkeepsie. And if you came from Columbia County, then a judge in Hudson. Well, who do you think the judge is going to pick? Any guesses? Himself? He can't do that. Any other guesses? A friend of the judge or a friend of yours? Now, who do you think the judge's friends might be? Lawyers. Well, indeed. I've been picked. Let's say the judge picks me as your legal guardian. The first thing I do is collect up all your investments, your bank accounts, IRAs, life insurance policies, the whole kit and caboodle, and move it over to my good friends at Wells Fargo. Why? Because I'm in charge. I have to file an annual accounting with the court. My law firm can be held liable for any losses. So I'm going to put it in a very safe place, and I'm going to tell them, in fact, invest that money where it cannot go down. I don't want to suffer any losses. You can give us the upside, no downside. Guaranteed investments, it can't go down. They have those. So I'm not concerned about my fiduciary responsibilities. They're discharged. And that's not the problem. The problem is today a lot of people recover from disability, strokes, heart attacks, serious operations. Now, when you recover, do you think you can take back control of your assets whenever you feel ready? What do you think? Not so fast, because there's a court order putting Attorney Ettinger in charge. So to get back control, you have to go back to court and have a trial and prove to the judge's satisfaction that you're able to handle your affairs, so the judge cancels the order, puts you back in charge. Can you see yourself here in your 80s or 90s, in court, on trial, fighting to get your own assets back? You can be shelling out $10,000 bills for the privilege because you're often paying for 3 or more lawyers. And you may not be successful. Not a happy place to be. And fortunately, it doesn't happen to our clients because they almost universally use trusts. And one of the first reasons is trusts avoid guardianship. And the reason they avoid guardianship is because, unlike a will, a trust takes effect while you're living, which is why it's called a living trust. And what happens in a trust is you set up a separate legal entity. Let's say your name is Mary Jones. You set up the Mary Jones Living Trust. Separate legal entity, you own it. And you name yourself Mary as the trustee, you're the manager. And you also name yourself the beneficiary, the person who has the exclusive use and enjoyment of the trust assets. So you wear 3 hats: owner, trustee, manager, and beneficiary. Now, for a trust to work, you have to put your assets into it. You do that by retitling assets. So if you have a deed to your home, we'll prepare a new deed, and we'll deed the house from Mary Jones to Mary Jones, trustee of the Mary Jones Trust, and we'll get that deed filed in the county clerk's office and returned to you. We'll show you how to change the name on your investments, bank accounts, and you'll retitle your accounts to Mary, trustee of the Mary Trust. And then you carry on exactly the same as before. You file the same income tax return as before. The trust uses your Social Security number. You buy and sell the trade the same as before. There's absolutely no difference, except like tens of millions of people around the country these days, your assets say Mary, trustee of the Mary Trust. The difference only occurs on death or disability. Well, first we're going to talk about disability. What happens if Mary becomes disabled? In that trust, Mary has written in, if I become disabled, I name so-and-so to step in. It can be 1 person, 2 people, or more. Well, the law says when you set up a trust where you name a backup trustee, this defeats a guardianship. So the judge cannot appoint a legal guardian if you said who you wanted, only if it didn't say who you wanted. So in the event of disability, you're going to get the person or persons you choose. Now, do you think it makes a difference if your people are in charge or the state's in charge? What do you think? Big difference, right? On a number of levels, but here's the main reason. in every elder law estate plan, one of the key features is you authorize someone that you trust. Most people use an adult child or more than one. Can be someone else. You authorize them in your elder law estate plan to transfer or protect your assets in the event of a disability, in the event you have to go into a nursing home. In fact, you authorize somebody to transfer all your assets out of your name. Why is that part of every elder law estate plan? Because we know under Medicaid, it's move it or lose it. So all of our clients have that. It's not generally something that lawyers do. A real estate lawyer won't do that, a divorce lawyer won't do that, but an elder law attorney will assist you in setting up a plan so that somebody can move all your assets out of your name. So what happens in the real world? Well, son will come to see us, let's say, and he says, Mike, you set up my dad's plan 20 years ago, and he has to go into a nursing home tomorrow. And he has about $500,000 in assets left. Can you help us save anything? So as a matter of fact, yes. Under the Medicaid law, we can take half the $500,000, which we know is $250,000, gift that to the children. As long as we spend the other $250,000 on dad's care, the family gets to keep the $250,000. And it's an advanced elder law technique, but it has a nickname. We call it half a loaf planning. How does the expression go? Half a loaf is what? Better than none. So you can always save half. Why? Because your family's in charge and you authorize to move the assets. But what if you're the type of person that says, well, you know, it didn't happen to my parents, so it's not going to happen to me. Or perhaps you might be a procrastinator and say, I'll cross that bridge when I get to it. So you get to the bridge. The bridge is around 86, 87 years old, the average age of a nursing home entrant. Now you have to go into nursing home, but you don't have a plan, so the state appoints a legal guardian. Now let's say you still have the same $500,000 in assets. Do you think the legal guardian could take $250,000 and move it to your family for safekeeping? What do you think? No, because once a legal guardian is appointed, they could only spend the money on you, the person that they're guardian for. You have the state's plan. Spend it on you till there's nothing left. So I'd like to share with you now the key insight that I've had in 20 plus years of elder law estate planning. And it took me, I'm 23 years at it now, just the elder law, and it took me 20 years because 3 years ago, I remember in January, 3 years ago, it finally dawned on me, and the bar has not realized this yet, but it's obvious once you hear it. And what is it? Planning for disability is more important than planning for death. They're still telling us to get wills. It's behind the times. Planning for disability is for you. A will is for them. And you come first. And it turns out that we all want the same three things if we become disabled. Number one, I want my people in charge, not the state. Number two, I want to be able to take back control whenever I feel ready. I don't want to be going to court asking a judge for permission to get my own assets, which permission might be denied. And third, I don't want to see that nest egg that took me 30, 40, or 50 years to build up. I don't want to see it disappear in 3 years because nursing homes are getting how much now in the area? Up to $15,000 a month. So planning for disability is crucial, and we're going to talk a little bit later. We just talked about how you save half a loaf. A little later, we'll talk about how to save the whole thing by planning ahead 5 years with a Medicaid Asset Protection Trust. So the first reason why wills are obsolete is an estate plan for 60 and over. There's no plan for disability. You risk getting the state's plan, which is appointed a legal guardian. You, of course, don't know who it'll be, and you have the state's plan. Spend it on you till there's nothing left. What's the second reason why wills are obsolete? It's because they have to go to court to settle. And what's the name of that legal proceeding to settle a will? Probate. And how large does your estate have to be to go through probate? Anyone? $1 million? No. It's $30,000. If you're 30,000 or over, that's a full probate. What is probate? Legal process to prove the will valid. A petition has to be prepared. And you have to make proof, well, at first it has to be served on all the heirs and the potential heirs. And in the petition you have to make proof that the person signing the will was of sound mind, memory, and understanding, able to read, write, and converse in the English language, wasn't under any fraud or undue influence. You may have to post bond. You have to file an accounting, an inventory. There may be other requirements of the court. And once the will is proved valid, the court issues a document called letters testamentary. It's an official document appointing an executor, and they carry on to collect the assets and settle the estate. A trust, however, doesn't go through probate because it's what's known in law as a will substitute. A will substitute means it gets the assets to the heirs, but it does it in a different way. For example, an IRA is a will substitute. Doesn't go through probate, goes right to the designated beneficiary. So an insurance policy and an annuity. Well, a trust, because it's a different legal structure, it doesn't go through probate. The backup trustees you name, one or more of your adult children generally, can be someone else, step in and they follow your instructions just like the will. After I'm gone, divide the assets equally among the heirs, but they don't have to go to court to get appointed. They do it themselves. For this reason, we get a fee of up to 3% to probate a will, and we get up to 1% to settle the trust. Let's take that $500,000 estate. Up to 3% to probate. What's 3% of $500,000? $15,000, thank you. The exact same assets in a trust, it's 1% to settle. Well, 1% of $500,000 is $5,000. So why is it $5,000 to settle the trust, but $15,000 to probate the will? The $10,000 difference is the cost of going to court. Today it's a 5-figure item, and you could be looking at multiple $10,000 bills. So you save a lot of money with a trust. You also save time. A number of years ago, Kiplinger's did a study, and they said that the average time to probate in New York was 2 years. It was twice as long as the nearest closest state. We settle the trust in weeks or months. Obviously, it's quicker because there's no court proceeding. We've been doing that for more than 2 decades. So you save money and you save time. But there's another reason I like trust, and it's actually how I got involved in the whole area of elder law estate planning. This was my first reason to get involved before I learned about elder law and disability planning. But my first reason was this. I used to be a litigator from 80 to 91. And I was riding down the Taconic State Parkway in 1990 chasing an ambulance. I was on a personal injury call, and I had the radio on, and I heard on the radio, if you set up a trust, you don't have to go to court to settle. I said, well, who wouldn't want that? I already litigated a number of estates. So I thought that was a great idea. So I looked into it, and I found out the best estate planning lawyers at the time were in Florida. Why do you think that is? Yeah, they call that heaven's waiting room. So I went down to Florida, got trained with some very good estate planning lawyers, came back and opened the practice. And the second reason used to be my first reason, because I was a litigator, so my first reason was to keep clients out of court. And here's why I like to keep clients out of court, and why I would like to keep each and every one of you out of that probate court. Because when you go to the probate court, who's in charge? The judge, right? Now tell me, does the judge always act in your best interest? No. Does the judge ever make a mistake? Every case I lost, the judge made a mistake. And when the judge says jump, your answer has to be what? How high, Your Honor? Now, with all due respect, if you have to go, you have to go. Here you don't have to go, much less send your nearest and dearest down to the courthouse to ask a perfect stranger there for permission to get the assets from you. Does it sound absurd? ARB said it 22 years ago. In 1991, the AARP did a study of the probate system in all 50 states, and they published a nice thick report called the Consumer Report on Probate. And in it, they advised the membership, at the time was 33 million members, that probate is just an unnecessary tax on our senior population, so they advise the membership to stop using wills, start using trusts. That started the living trust revolution, now more than 2 decades old. And so the reason is, the second reason why wills are obsolete is because they have to go to court to settle, and the trust avoids the probate. So it avoids a potentially time-consuming and expensive court proceeding for your loved ones after you're gone. It just makes perfect sense. What's the third reason why wills are obsolete? Well, this is a little bit different. The third reason why wills are obsolete is because they tend to be single-generation planning. And single-generation planning has proven to be defective. Now, we didn't know about this, or it wasn't important when estates were $3,000, $4,000, $5,000, not that long ago. But when estates started becoming $300,000, $400,000, $500,000, sometimes more per child, people started to realize there's this problem. And here's the defect. Most wills read to my children in equal shares per stirpes. And you know what the per stirpes means? If heaven forbid my son or daughter dies before me, their share to their children. Sound familiar? Yeah. Did anyone say if my son or daughter dies before me, their share to my son-in-law or daughter-in-law? Did anybody say that? No. And yet in the real world, what happens? In the real world, most children survive their parents. So let's say when you died, you had a son, we'll call him Bobby. And you left Bobby in your will $400,000. Bobby gets the $400,000. Your estate is closed. 3 years later, Bobby dies. Who gets the $400,000 from him? Your daughter-in-law. Can she get remarried? Share your $400,000 with a complete stranger? Well, she will. People live 31 years longer than just a century ago. And as I said, this wasn't a problem when the estates were $2,000, $3,000, $4,000. But when they're $300,000, $400,000, $500,000, sometimes more per child, people are realizing that there are ways to keep it in the blood. And this has become fairly mainstream. My firm has been doing this since 1998, so we're in our 15th year. And many thousands of people have set it up this way. Instead of leaving the $400,000 to Bobby, they're setting up a Bobby trust. They're writing it up today. It's called an inheritance trust. They're doing it for their sons and daughters. So they're saying to Bobby, Bobby, I set up a trust for you today. It's empty. It's a standby trust, standby till I'm gone. And when I die, the $400,000 is going to the Bobby trust. And I appoint you, Bobby, as the trustee. You're in charge. And in fact, you can do whatever you want with the money. You could spend the whole thing. So I'm not ruling from the grave. But these trusts have 3 benefits. First, they say, Bobby, if you happen to get divorced, what's the divorce rate in this country? Half? Spouse can't touch it. Separate property protected by the trust. It already makes sense. It says something else. It says, Bobby, if you get sued. Who gets sued today in this country? Everybody. Thank you. Creditors can't touch it. Not his name, not his social security number. Lawsuit proof. But the third thing, and the main reason people set up the inheritance trust, this trust says, Bobby, when you die, might be 5 years after me or 50 years after me, whatever you didn't spend in the trust, that goes to your children, not your spouse. His children are, for many of you, your grandchildren. Now, what if he doesn't have children? Then it goes to Billy and Mary, the brother and sister. Then it goes to nieces and nephews. But it always passes by blood instead of by marriage. Keeps your money in your family for generations to come. Does this sound like a good idea to you? Must be. It's what most people with assets do. It just makes sense. So what's the fourth and final reason why wills are obsolete? Well, wills do absolutely nothing to protect your assets from the extraordinarily high costs of nursing homes. So you have the will, so you name the executor, so you have the beneficiary, you have the percentages, and maybe it's written in calligraphy. But unfortunately, the client went into the nursing home got everything, the family got nothing. You know what that plan reminds me of? The old saying, the operation was a success, but the patient died. Now, in our view, at least for the last 20 plus years, if a plan doesn't have an effective way to protect the assets of a nursing home, it's got a great big hole in it. It's no plan at all. So all of our clients have it. And it turns out it's not that difficult. There are two main options for protecting your assets of nursing homes. Either you purchase long-term care insurance in an amount adequate to cover the cost of care, or you set up something called a Medicaid Asset Protection Trust, the Medicaid Trust for short. Well, first, long-term care insurance. In my view, long-term care insurance is the way to go if you can swing it. It's plan A. Why? Because it pays for home care. I want to age in place, they call it. I want to be able to stay in my own home. I don't want to end up in a nursing home because I couldn't afford to stay in my own home. So I want that insurance to stretch my dollars for years longer so I can stay in my own home as long as possible. So for home care. But the second reason is if you have a spouse. Later in life, of course, sometimes one of the spouses become disabled. By disabled, it's actually a term of art. In elder law, it means unable to perform any two or more of the activities of daily living, the ADLs, activities of daily living. Washing, dressing, transferring, getting in and out of bed. If you can't perform two or more, you're considered, quote, disabled. Well, what if it's your spouse? What happens is the other spouse, not the disabled spouse, finds out fairly quickly it can cost $4,000, $5,000, $6,000 a month to bring somebody in. The next thing they say is, well, if I start spending that kind of money, I may not have enough left for myself. So often they decide, I'll do it on my own. Well, Alzheimer's Association did a study, and you know what they found out? Over 60% of spouse caregivers are dying first. Why is that? Stress, right? Yeah. Well, imagine this. The caregivers generally in their 80s or 90s. The job is 24/7, 365. It's a very hard job, and you're not trained for it. Just a recipe for disaster, and that's exactly what happens. So we like the long-term care insurance if you have a spouse, because if you're unable to perform any two or more of the activities of daily living, this triggers the benefit. And now you call and the insurance company pays for the care, you supervise, but somebody else does the heavy lifting, and you get respite. You know, that's a break. You're not on 24/7. Visit a relative, take in a movie, recharge your batteries. So I like the long-term care insurance, but that's the financial advisors area. That's Wells Fargo. Lawyers in New York do not sell insurance. But we advise on it. And here's what I advise each and every one of you, and I just advised the client today of this. Don't have the decision on long-term care made for you. You make the decision. And by this I mean, if you wait till 70 plus, the premium gets so high, very few people could afford it. Or if you wait too long, they may find a medical condition that knocks you out of the box. You don't qualify. You get turned down. So better, in my view, to have it looked at, consult a professional. They look at your age and your health and your assets, your income. They tell you how much they think you need per day, considering your situation, how many years coverage you need. And once they develop those parameters, they shop it around. And now my job is done. That's where I want you to go. And now your job is now to make a business decision, not a legal decision. Are you going to insure against the risk, or are you going to risk your own assets? Only you can decide that. But you cannot decide without the information. So I suggest strongly get the information. I have absolutely no problem with a client coming in and saying, Mike, we had it worked up. We looked at it. We decided against. Okay, fine. If you decided against, you got turned down, you can't afford it, then we look at Plan B, the Medicaid Asset Protection Trust. Let's call it the Medicaid Trust for short. The Medicaid Trust has been around as long as I've been practicing. It is the way that middle-class people protect their assets if they have to go into a nursing home. There are only 3 ways to qualify for Medicaid. It's not like Medicare. Medicare is for hospitals, doctors, skilled care. We all get Medicare so far. But Medicaid is a different program. That's for custodial care, nursing home care, help with washing, dressing, getting in and out of bed. Medicaid is what's called a needs-based program. You have to qualify. And there's 3 ways to qualify. Either you're poor, you spend down all your assets till you become poor, or you shelter your assets. Which one do you think is the most desirable of those 3? Shelter your assets. Well, the federal government pays for half of the Medicaid program, quite a few $billions. And when they send that check each year, naturally they have some terms and conditions. And one of the conditions is, it's federal law, that you be permitted to set up a Medicaid trust. A Medicaid trust is known as an irrevocable trust. It's not like the revocable living trust, you're married, trustee the married trust. If you're in charge, they'll say, Mary, you're in charge, take it out and pay for your care. If you can get it, they can get it. So to protect your assets, you use a different type of trust, an irrevocable trust, and that trust sets up 2 roadblocks that Medicaid and nursing homes simply cannot break through. The first roadblock is, you may not be the trustee, you have to pick someone else. People almost always choose one or more of the adult children. Medicaid has no control over them. The second roadblock is, in the Medicaid trust, you must limit yourself to the income only. You put in stocks, you only get the dividends. CDs, you only get the interest. Your home, it doesn't earn income, you get the equivalent. Exclusive right to live there, use and enjoy that property during your lifetime. What happens to these assets? They stay in the trust, and then at your death, they go to your heirs, free of the expense and delay of a probate. So who is setting up the Medicaid trust, and why are they doing it? Middle-class people like us, 70 plus, at my firm, generally have a lot of assets you're not going to spend, like your home. For heaven's sakes, move to protect your home. You put in the trust, and you have the exclusive use and enjoyment of it. You pay the same taxes as before. You keep all your exemptions. And then anytime after 5 years, if you have to go into a nursing home, you can't touch the home. It's exempt. What if you don't make the 5 years? What if 4 years go by, you have to go into a nursing home? In that case, you only have to pay for the 1 year that's left. It prorates. It always pays to get started. So we've done it for people in their 90s. We do it for people in failing health, because whatever you get under your belt, it's better than if you never started. So you put in your real estate. What else do you put in? IRAs are exempt. They don't go in. 401ks, 403b, TIACREF. Your qualified monies, like IRAs, are exempt. Now, if you're over 70 and a half, you're in payout status. They call that the required minimum distribution, RMD for short. You know, once you're 7 and a half, you have to start taking out. Starts roughly around 4% a year. If you're in a nursing facility, they get your RMD because it's coming out as income. But let's say your RMD is $3,000 a month, and the nursing home is $15,000 a month. Can they go to your IRA and get the other $12,000? No, because the principal of the IRA is exempt. On your death, it goes to your heirs. They don't have a lien on it. They can only get the income from the IRA. So you don't put in qualified monies. But what about non-qualified? Do you have bank accounts, CDs, money markets, savings? Do you have stocks, bonds, mutual funds, treasury bills, municipal bonds, savings bonds, annuities? If it's not IRA type money, then it's fair game, and you have to spend it down until you qualify for Medicaid. Now, if you have a spouse, you have to spend down to about $125,000. That's the allowance for the spouse at home. But do you know that over 80% of people in nursing homes don't have a spouse? So not too many people get the $125,000. Most people are the single. And the single's allowed to keep, how much you have to spend down to? About $14,000. So if you have more than that, you can't qualify for Medicaid unless you spend down to those limits. Now, turns out at 70 plus, people have a lot of assets they're not spending. They have a nest egg, but they're either reinvesting it or just taking the income. So if you're not going into the principal, do you realize that you're actually safekeeping it for the nursing home industry? You don't, but you get there, 86, 87, and you have a nest egg, a few $100,000, $300,000, $400,000, $500,000, whatever it is, And over in the business office, they're jumping for joy. Why? Because they're going to be getting up to $15,000 a month from you. Most people in the facility are on Medicaid. The vast majority. Is Medicaid paying them $15,000 a month? Of course not. Are you getting the same care as everybody else? Yes. So it's a home run for them. It's a strikeout for you. Not a good place to be, and you don't have to be there. You could take those assets, put them in the Medicaid trust, you get the income, still there if you need it, but somebody else can't come and take it away from you. This is the type of thing we talk about in the consultation. And this leads us really to the purpose of the workshop, is to prepare you for the consultation. It is free. And you folks, most of you would meet with me. It may not be possible to meet with all of you, but the other lawyers in my firm also give this seminar. 4 of them. And they could have done this one tonight, but I happen to be a resident of this town for the last 17 years, and I have a home here. So, and the office is right next door in the M&T Bank building. So I'd like to do this seminar, and I hope to see most of you. So to that end, may I ask you to reach into your packet, and on the right side, in the back, there's a pink form and a blue form. Would you please take both of those out? Okay. And let's look at the blue one first. This is your confidential planning survey. This is the one you take home. Fill it out at home. Take you 10 or 15 minutes. You'll see your name, spouse if you have one. If you don't have a spouse, I wrote a chapter in my book on estate planning for singles. Put down, you have issues. They're just different. Put down your children. Again, if you don't have children, I also wrote a chapter on estate planning for people without children. Again, different issues. Now at the bottom it says if you're a couple, our primary planning concerns are, check all that apply. Well, first, planning for disability. Probably a good idea to check that. Elimination of probate. Everyone checks that. No one wants a probate. Minimizing estate taxes. A word about estate taxes. The federal exemption, we know, was renewed at about $5 million. Okay. Do you think you can squeeze under the limit? Anybody? Probably not too difficult. The New York State estate tax starts on estates of $1 million. What's your estate? Your home, all your real estate, investments, bank accounts, IRAs. And get this, any life insurance that you own is part of your estate for estate tax purposes. You have a $300,000 policy, that could put you over the $1 million. Add it all up, if you're under $1 million, it's just not an issue. If you're over $1 million, the tax is roughly this. On $1.1 million, you owe $40,000 to Albany. At $1.5 million, you send $65,000 to Albany, and at $2 million, you have to send a cool $100,000 to Albany. Now, you can avoid the tax perfectly legally if you have a spouse and you create 2 estates. So you can each pass $1 million tax-free. How do you do this? By setting up 2 trusts, one for the husband, one for the wife. And you can both be trustees, husband and wife trustees on husband's trust, but uses his Social Security number, wife and husband trustee on her trust with her social. Now, it's not just setting up the 2 trusts, you have to split the assets. You deed the house half to the wife's trust, half to the husband's, you split up the monies. If you split it up, you can each pass $1 million tax-free. How much do you save? $1.1 million, you save $40,000. $1.5 million, $65,000. $2 million, you save $100,000. But you don't get the $2 million exemption. You don't get 2 exemptions just because you have a spouse. You only get it if you set up the 2 trusts and put the assets in when. You must do this before the first spouse dies. Now, if you know when that is, you just come in a few days before. Straighten out the whole thing, okay? Okay. Next item, planning for parents. If you have older parents, you may want to talk to them about the Medicaid trust. Could be saving $15,000 a month. And not only your parents, but also your adult siblings. You want to talk to them about it. You want to send them to the website. It's trustlaw.com. It's right on the cover, and it's on the inside. On the website, this is being filmed for the website. That's why you see all the cameras, so they can watch this seminar. They can read articles from my book on the Medicaid trust, etc., educate themselves, and then you make a family decision whether or not that Medicaid trust might be a good idea. Always pays to get started. If you have a special needs child or grandchild, we want to talk to you about the special needs trust, which only pays over and above what the government pays, so they don't lose their Social Security, their Medicaid. You can leave an inheritance to a child, but if they're special needs, it has to be in a special needs trust. On the right side, you want to protect your assets from nursing home costs. Check that. You want to keep it in the blood. Remember, that's the inheritance trust. Divorce and creditor protection for the children. Again, the inheritance trust. Protecting children from poor spending habits. I think it's an epidemic. Certainly is common. And you have a lot of options here. You can hold it back. You can spill it out over a period of years. Put somebody else in charge. Give them the income only. One of the things we do on larger estates sometimes is we say 20% at 30, half of what's left at 35, the rest at 40. The theory there, they get to 20%, they blow it. They have to wait 5 years before they get the next half. And finally, 10 years later, when they have some smarts, you still preserved half the estate. There are a lot of options there we can talk about. Does anyone here, may I see by a show of hands, does anyone here own property outside New York State? Own property outside New York State? Anyone, a couple? Yeah. Where's that, ma'am? Maine. In Maine? Very nice. Vermont? Great. What happens if you have a will and you own property in another state? You have to probate in both states. There's a name for this problem. It's called the multiple probate problem. You need a lawyer here and a lawyer there. You pay for 2 probates. Easiest thing to avoid. When you set up a trust, we'll deed New York and any of the other 49 states into the trust and avoid all the probate. So word to the wise. You own property in another state, you generally are going to want to use a trust. Now if you look inside on the blue form, there's some yes-no questions. That's our due diligence. Tells you what to bring with you. Bring your will. Bring your trust if you have one. Your power of attorney. Healthcare proxy. Living will. The deeds to your real estate and at least 1 real estate tax bill for each property in case you want to put it in the trust. Your statement from brokerage accounts or just fill out the financials. If you have long-term care insurance policy, let's look at that. Then you fill out the financial information. And here's how the estate planning process works. Generally, there's 3 meetings. The first meeting, we're getting to know each other. Your children, what kind of work do they do? Where do they live? Your son-in-law, daughter-in-law, what are their names? What's your relationship, good, bad, or otherwise? Grandchildren, how old are they? What are their names? What's the family dynamic? Doesn't take long. Everybody knows their family, at least from your point of view, which is what concerns me. So I get to know you and your family, what's important to you. I look at your financials, your assets, your income, and then I look at your current documents. And I see, does the thing hold together? Does it look like a plan? And usually it doesn't. Why? Because virtually no one who's ever come to see us at Ettinger Law Firm has ever met an elder law estate planning attorney. So there are gaps. They may not have a plan to avoid probate. They may not have a plan to avoid guardianship. They may not have anything to keep it in the blood. Protected from children's divorces, lawsuits, and creditors. No plan to protect the assets from a nursing home. So I'll review what you have. I'll tell you where the gaps are, or the documents you have may be out of date. The power of attorney may be stale. It may be the old form. They changed the new form in September of 2009. And I'll tell you where the gaps are, and I'll tell you what I think you should do to close those gaps and why, what your options are, what decisions you have to make. I'll give you a copy of my book. It's a thank you for coming. And also, there's homework. I'm going to tell you, please read these chapters. These are the ones that apply to you, 1 to 6 and 13, or 1 to 5 and 20. And I'll also tell you what the fees will be, because I learned over time from people, everybody wants to know. So I'll tell you, this is what it's going to cost. We're not making that decision whether we're going forward, but you know where you stand, and everybody likes to know where they stand. If we're moving forward, we have a second meeting, which is a little more formal. Now you've answered some questions, you brought any missing information, you made some decisions. we're going to give you a 2-page proposal in writing. Now it's detailed. This is what we're going to do. The fees are reduced to writing. And we'll draft the estate plan together. And then if we're still moving forward, that's the decision-making time. And if we're moving forward, the law firm will go ahead, prepare all the documents. You come in, you review them. Everything's satisfactory. Everything is signed. You're happy. We're happy. Then you actually hire us. This is unique. At our firm, we don't take a retainer. You know what a retainer is. Lawyers say, give us something to start and then the rest at the end. We don't take a retainer. At the end, when the client signs the check, that's when they're actually hiring us. That's your contract. So when I give you the proposal, we sign it, but you don't sign it. Why do we do it that way? Well, a couple of reasons. One, it acts like a guarantee. You know, you're always in the driver's seat. You don't pay anything unless and until you're satisfied. So I don't meet a lot of the clients these days from the firm because there's a number of other lawyers who give the seminar and meet those clients, but they all get the guarantee. So that's my way of doing something for the clients. But the second reason is this. At Ettinger Law Firm, we're doing something very different from other firms. And I'm not knocking any other firms because this is the rest of the US of A. When you sign with them, they say goodbye. You never hear from them again. Well, you know this from your own experience. When you sign with us, we're saying hello. Now we're going to write to you once a week. Now we're going to have you to breakfast every couple of years. We're tracking your plan. If there's a law change, we'll send you a letter that something is affecting your plan. And finally, every 3 years, we'll call you in for a free review. See if there's any change in your family, births, deaths, marriage, divorces, anything else happen. So in the average 12-year period, we'll see a client maybe 8 or 9 times. Now, don't you think it makes a difference when something bad happens that you know the lawyers and the staff? I can tell you, it makes a huge difference. Qualitatively, in the office, we see it every day. When something happens to a client, we know who it is. And they know who we are. It makes a big difference. I just recommend it highly to you. It's not something that you can describe in words. You know, you have to experience it, but we have thousands of clients. It's also very satisfying for the firm, the lawyers, and the staff to have relationships with the clients. And, you know, you meet a lawyer and the staff 8 or 9 times in 12 years, you develop a fairly good rapport. So, again, I recommend that to you. And it's free for all our clients. Now, if you would please take out the pink form and take up your pens. We're going to fill this out together. It's the request for consultation form. Please fill in your name, spouse if you have one, your email address. Now, we don't share this with anybody, but if you choose to give us your email address, we will send you the Ettinger Elder Alert once a week. Now, clients seem to like it very much because we get a lot of quality information into the firm because we have a number of resources. And we take, either I write the article or we take the best article we've received from our sources every week and we share it with the clients. I think you'll like it. And you don't have to be a client to get it. It's free. It comes by email. All right. It says free consultations underneath that, and then it says please check the following. The first is elder law estate planning consultation. Underneath that it says yes, I'd like an elder law estate planning consultation. May I suggest you check yes, come and see me if you only have a will, come and see me if your will is out of date, and come and see me if you want to discuss whether or not you should have a trust. When you check yes, one of the staff at my firm will call you tomorrow morning, they call the next day, and they'll make an appointment to see me sometime in the next few weeks. As I say, I'll see most of you. If not, you would still see a senior elder law attorney, perhaps Bonnie Cram, who is a senior attorney and a former judge and very experienced. But I would probably see most of you. You make the appointment. It's very low-key. You'll be very comfortable with the experience. And I certainly enjoy it, and I think the clients enjoy coming in and talking about it. Financial investment consultation, that's what was with the representative. Tonight it was Anthony Dinallo from Wells Fargo. It says, yes, I'd like a financial investment consultation. Well, I generally recommend you check yes and see him. If you're not happy with your advisor, you might want to see him if you don't have an advisor. This happens all the time. I had a client in the office today. $300,000 in CDs. Why do you think that is? Because they're more concerned with safety and security than anything else. But they acknowledge to me that it's not really that safe and secure because their purchasing power is going down. You're actually losing money. It's a slow loss, but it's a loss nevertheless. See what you can do with that same money 10 years later. Money has to grow to offset inflation. There are guaranteed investments. You can get 3%. You don't have to take the 0% from the bank. But you have to talk to a financial advisor. You can get a guaranteed annuity. They're guaranteed both by the insurance company and the state insures them up to $500,000. You may want to talk about that. And should you see him if you're happy with your advisor? Well, yes. I learned of some studies where they found that a lot of people are happy with their advisor because they're nice people. And because they're nice people, they like them. And because they like them, they never actually scrutinize and find out if they're doing a good job. Well, if you talk to these folks at Wells Fargo, they'll analyze it, and they'll tell you if they think they're doing a good job or not, if they could do better. And then you're a free agent. If you want to change, you can do it. But nothing ventured, nothing gained. You're a free agent there. I have no stake in that between you and them. But I always suggest a client get a second opinion on the financial. Long-term care insurance, that's with Wells Fargo. If you want some quotes, check yes. They will get your information. They'll shop it around, get you 4 or 5 quotes, and then you'll make your business decision what you want to do. And then finally, speaking engagement. If you have a senior retiree group that you'd like me or one of the other lawyers to speak to, check yes. We do it free of charge. Patty Brown, my firm manager, will call you. She'll make an appointment or set it up, and I'd love to do it for you and your group. So let me now thank you for listening. It's a lot to take in at one sitting. And thank you for your patience, and thank you for coming. And let's open the floor. Any questions? And because this is being recorded, I'm going to repeat your questions. So, yes, sir.
You talked about changing the rules going on. The reason for changing the trust issues. As they change, do you require new fees for the new changes?
Okay, so what the question is, you come in for the review every 3 years. If you need a change, is there a charge for that? Well, of course there is. You pay for, the system is free, so we're monitoring and maintaining it. You come in, you don't need anything, fine. See you in 3 years, see you in 6 years, you know. Again, but when you need a change, you'll pay for the amendment to the trust. Might cost you, these days, costs maybe $375, not significant. But some people, a lot of people over the years, thousands actually, set up revocable trusts with us. They needed the trust at the time, and they got older, and they decided, you know, we couldn't get long-term care insurance, we got turned down, now we're going to do an irrevocable trust. And they paid us the full fee over again, because they wanted to. So we present it, and you decide if you want to do it. That's how we work. Anyone else? Yes?
Is a revocable trust as good as a regular trust?
Is a revocable trust as good as a regular trust? A regular trust is not a term of art, ma'am, so I don't know what you mean.
Revocable, I had been told if it's revocable, it's really not that good because you could at any time end it faster than when it's a...
Well, perhaps what you're getting at is, I think what you're saying is, yes, now I figured it out, is a revocable trust as good as an irrevocable trust? Well, revocable trust does everything. It avoids probate. It avoids guardianship. If you're over $1 million a couple, it saves estate taxes. Can keep it in the blood. Protected from children's divorces, lawsuits, and creditors. The revocable trust does not protect your assets in nursing home. But we can't say it's not as good as the irrevocable trust because you may have adequate long-term care insurance that pays for that, and you don't need the irrevocable trust. The irrevocable trust does everything the revocable trust does, plus one more thing. It starts the 5-year clock running to protect the assets of a nursing home if you need it. If you need it. Yes. Yes.
I have a three-part question. Right?
Three-part question.
Do you lose your store exemption on your primary residence if you put your house into an irrevocable trust?
If you put your house into an irrevocable trust, you do not lose any exemptions. You don't lose the STAR, the senior exemption, or the veterans exemption. They're all preserved.
Okay. 2, can I change the beneficiary easily?
Can you change the beneficiaries easily? On the trust?
On the irrevocable trust?
Yes. In the irrevocable trust, you wisely reserve the right to change the trustees who's managing it in case you don't get along with them, you have a falling out, and you also reserve the right to change who you leave it to. That is a good idea because obviously things change.
And then the third question is, why can't one put one's own house into the children's names and put your money into an annuity and save it for Medicaid?
Why can't you put the house in the children's name, put your money in annuity, and protect it from Medicaid? Well, if you put the house in your children's name, you're subject to all their debts and liabilities, divorces, lawsuits, and creditors. Is that a place you'd feel comfortable in?
That's part A.
That's part A. If you put in their children's names, you're going to reserve the right to live there, I hope.
Right, of course.
Now, if you have to go into a nursing home, that house is now vacant. They can sell the house, but they have to pay the nursing home the value of the life estate because it still has a value. And it's high because Medicaid sets the rule. Couldn't they rent the house? Well, if they rent it, who's the life tenant? It's you, so the rents go to the nursing home. So they could have to carry that house empty for years. The life estate deed is a trap.
So you have life...
Excuse me, ma'am. I'm sorry. This is not the consultation. They have to come back to the office. I can't go back and forth with you here.
Okay.
And you did have 3 questions. Now the other one was about the annuity. I didn't finish. The annuity is not protected from Medicaid. You have to name Medicaid. If you have a spouse, you can name your spouse as the beneficiary. But if you don't have a spouse, you have to name Medicaid as the beneficiary of the annuity to the extent of the Medicaid benefits paid. Any other questions, you'll have to come to the office. And you did remind me of a lawyer joke, so I'd like to tell it. Would that be all right? Yeah. Have you heard this one? Fellow goes into a lawyer and says, "How much do you charge?" The lawyer says, $500 for 3 questions. The fellow goes, "Wow, isn't that kind of high?" The lawyer goes, "Yeah, what's your 3rd question?" Yes, ma'am.
If you have a mortgage on your home, can you still put it in a trust, and does the mortgage...
If you have a mortgage on your home, you can put it in a revocable trust. It's not an issue. The federal law allows you to do that. If it's an irrevocable trust, well, it's going to depend on the lender. But usually people 70 plus very often haven't, they have their homes paid off. And generally, if, it's different for each case. We have to talk about it in the office. Yes, sir.
If you get long-term care and you move out of state, it's still good, right, no matter where you go?
The long-term care is good anywhere as far as the benefit. So if it's $200 a day for 3 years, it's good in any state. What I think you're getting at is the New York State Long-Term Care Partnership. There is a special policy. It's called a partnership policy. It's a partnership between New York State and the insurance companies. And what this partnership policy does, it says you buy the benefit, which is currently you have to buy 4 years worth, I believe, of long-term care insurance coverage. And the state agrees that at the end of that policy, if you still need benefits, they'll give you Medicaid. They won't go after your assets. They'll limit themselves to your income. It works like a Medicaid trust. So they agree not to pursue your assets, only your income. Now, if you have the partnership part you can only exercise in New York State. So while the 4 years is good anywhere, the partnership part you have to come back to New York State for. Anyone on this side? Wonderful. A last one.
Do you have a fixed charge for making up a trust, or does it change with the complications of whatever it is?
Well, we generally have set fees. Depends, do you need 1 trust or a couple? You need 2 trusts. Is it over $1 million or under? Because the 2 trusts have tax language in them. Are they revocable or irrevocable? Do you want inheritance trust? If so, how many children do you have? Is there deed work? How many properties do you own? But we have a fee schedule. It doesn't depend on the size of your estate. It just depends on what you need.
So what is an approximate figure of what you charge?
Well, approximate figure is hard because, you know, I just laid it out. It's quite different. But today, estate planning fees would run between, say, $3,000 and $7,500, although some clients have paid more, it's more complicated. But I tell people, try not to be too concerned about fees, because the consultation is free, but also, if the value is not there, we will tell you. Not only I, but all my lawyers are trained that way. When a client comes in, and we do this many, many times a week, this doesn't make sense for you, the value is not there. It has to be worth a lot more than you're paying for it, or we won't recommend it to you. And it's not hard. I mean, if people need to trust, or they want to protect their assets in nursing home, or they want to keep it in the blood, or they have special needs or other issues, lots of reasons to do it. But if the value is not there, we'll be the first to tell you. So thank you again for coming. Thank you for listening. Please stay for dessert and coffee. Look forward to seeing you all in the office very soon. Thank you very much. Thank you.